Good morning. I would like to talk to you today a little bit about our court system. Understanding the court system will help you to understand the court cases that you're reading. This is an area of procedural law that is very important. So let's get started. First of all, I want to mention some learning objectives. One area that you need to understand is the role of the key personnel associated with the courts. What is the judge's job? What's the jury's job? The other thing you need to understand is to know the organization of the state and federal court systems. Again, very important so that you understand when you're reading a judge's opinion what the structure of the system is and where this opinion stands in terms of authority, in terms of what it means. So this will help you. There are two systems. Let's focus on that first. There is the federal system and the state system. So make sure you remember that. And you've got to decide where to file your court case. So we're going to talk a little bit about jurisdiction, which is the power to speak on the law in a particular case. Courts sometimes have to decide whether they have jurisdiction in a case or not. So there's two systems, federal and state, and you must decide which one your case will be filed in. Each of those two systems have three tiers. So you know there's going to be basically the lower level, which is usually a trial court, appellate court, and then a Supreme Court in both systems. So let's talk for a minute about the trial court. That's where you're going to start your case. It will either be your trial court in the state system, which is normally in the local county courthouse, or it may be in the federal U.S. District Court in the Eastern District of Arkansas, for example. Trial courts have what's called original jurisdiction, which means that's where you start. You don't start your case at the U.S. Supreme Court, which is the highest court in the land. You start at the bottom of the tiers, and if you need to appeal, work your way up. Some trial courts have limited jurisdiction. In some cities, there may be a separate court for probate and will matters, or for divorce matters, child custody matters, those types of things. Some trial courts have general jurisdiction. There does need to be a real case. So if there is just a hypothetical question, for example, or something that is just kind of meaningless, or something where you're just trying to get legal advice, then there is no jurisdiction in any court. There must be a real case or controversy in order for a court to have jurisdiction. So trial courts are there so that the jury, if there is one, will hear the facts and decide the facts, guilty or not guilty, for example, and the judge will apply the law. In some cases, the parties will waive a jury trial. If they do that, then the judge will decide the facts and the law in those cases. You do start your case at the bottom, at the trial court, and then there is appellate review. A court of appeals doesn't hear the evidence all over again. There's not a new jury. There's not a lot of testimony in the court of appeals. The trial court is where the evidence is heard. So what's the job of the court of appeals and their justices? If you lose your case in trial court, whether it be the U.S. District Court or at the local courthouse in the state court system, you may want to appeal if you think there was an error on the law. The Court of Appeals doesn't let you put in more evidence and that kind of thing, but they will look and see, was there some error by the trial court judge in terms of how they stated the law or applied the law. The appellate court can agree with the trial court judge. If so, they can affirm. If they disagree, they can reverse, which means something has to happen. Either, the trial court has to change what they enforce, or it may be remanded, sent back to the trial court for more determinations. Or sometimes it can be partially affirmed, partially reversed, or modified. And so the appellate court has a very important job, but they don't rehear evidence. So let's look at the 3 tiers in the federal court system. Now there are some special things about this. The lower tier is a little more complicated than just one. There's also U.S. Bankruptcy Court here, which kind of branches off the district courts. In the U.S., there's 96 district. There's also some federal agencies, tax court, those types of things all here that will affect the lower tier. So if you're filing bankruptcy, you will go straight to U.S. Bankruptcy Court as your first step. Now the second tier is the U.S. Court of Appeals for the 11 circuits in the D.C. Circuit. And there's also a U.S. Court of Appeals for the Federal Circuit, which would include U.S. Claims Court, International Trade, Patent, Trademark, that kind of thing. So if you lose down here on the first tier, you would appeal to the second tier courts. If you lose there, you would go on up to the U.S. Supreme Court. It's very hard to get in the door of the U.S. Supreme Court. You have to ask their permission, and they only hear maybe around 80 to 100 cases a year by granting what's called a writ of certiorari. If you want to get in the door of the U.S. Supreme Court, you have to apply for the writ of certiorari and be prepared, because the odds are, in many cases, you're going to be turned down. They only pick the most important cases of the year, in their view, to hear. It is expensive to go through the first tier trial. Then there's even more expense if you keep appealing. And so some parties quit after the very first tier and don't ever end up in the U.S. Circuit Court of Appeals or the Supreme Court. Now, do note, there's only 11 circuits in the D.C. Circuit. Excuse me. Arkansas is in the 8th Circuit, and we're combined with several other states to make up that circuit. Now, the state's court system is here, and we have basically the lowest tier, which is where you start your case in the court of original jurisdiction or the trial court. Then you go to the state court of appeals if you lose and you want to appeal, and then the state Supreme Court. Once in a while you can go straight from the trial court to the state Supreme Court, but not all the time. Now, in a very few limited situations, you could go from the state Supreme Court to the U.S. Supreme Court, but I wouldn't count on that happening a lot. Now, how do you decide? Okay, we've talked about the 3 tiers. We've talked about what jurors do. We've talked about judges and trial courts do. And we've talked a little bit about what appeals courts judges do. How do you decide where you're going to take your case? Are you going to take it to federal or state court system? Well, if you have questions of federal law, questions about the U.S. Constitution, that kind of thing, you're probably going to end up in federal court. If you have a divorce, probate, negligence case, that kind of thing, you may end up in state court. Now, what's in the middle here? This diversity of citizenship. If you don't have a federal question, but you still want to go to federal court, you can try to go to federal court using this, even if it's a matter that would normally go to state court. An example might be, suppose that a trucking company in Arkansas, who has incorporated in Arkansas and has its principal place of business in Arkansas, travels to Oklahoma. The driver negligently runs over a citizen of Oklahoma, and that citizen wants to sue. Well, the citizen of Oklahoma may want to sue in the Oklahoma federal court system, and they would be able to do that if there was diversity of citizenship. So if the corporation and the truck driver are from Arkansas and the other party on the other side is from Oklahoma, and there's no overlap of states there in terms of where the parties are from, and the case is worth more than $75,000, then there can be federal jurisdiction. The reason why this is allowed is to prevent some kind of local favoritism. We wouldn't want a local court judge in Oklahoma to be unfair to the Arkansas company just because they weren't from Oklahoma. There's a little more likelihood, in the belief of some, that a federal court would be less likely to have that kind of a federal court would be more likely to be fair to the Arkansas corporation. But they won't take just any case. It does have to be more than $75,000. And the parties have to be from different states in order for it to fall into this diversity of citizenship category. All right. So remember, as you go through these slides, all the important things. Let's go back and look at those objectives again. Remember, the job of the jury is to find facts. The job of the judge is to determine the law. If there is no jury, the judge determines the facts and law. That's at the trial court level, or the lowest level, the lowest tier. After that, when there's appeal, the job of those judges are to examine the decision of the trial court and look at errors in law. Also remember how the state and federal court systems are organized, and remember those 3 tiers that we've talked about, and think about which court your case might belong in depending on the situation. Is there a federal question or diversity of citizenship? Then you may end up in federal court. If there is no diversity of citizenship and no federal law type question or no U.S. Constitution question, you may end up in state court. All right. Thank you very much for listening, and I hope you have a great day.